Hello and welcome to the final of the National Speed Mooting Competition Winter Cup on the 5th of December 2020. In the final, we have Annabel Hazlitt taking on Melissa Jarvis. Annabel will be representing the appellant and Melissa will be representing the respondent.
If it please the court, my name is Annabel Hazlitt and I represent the appellant, Mr. Miller, in this case. My learned friend, Miss Jarvis, represents the respondent, the Crown. The appellant submits that the decision of the High Court should be overturned and a special reason should be found not to disqualify Mr. Miller from driving. May I first inquire if my lords have had sight of my skeleton argument at page 12 of the electronic bundle? I am grateful. In my submissions, I will primarily focus on the factors set out in Taylor and Rajan 1974 Road Traffic Reports 304. May I please ask to dispense with formal citations? I'm grateful. This is at point 3 of my skeleton. I shall bring in points 2 and 4 when necessary. Overall, I'll make 4 submissions. Firstly, I submit I will deal with the appellant's blood alcohol content. Secondly, the nature and degree of the emergency. Thirdly, whether there were any alternative methods of transport available and why we submit that this is inconsequential. And fourthly, the manner of the appellant's driving. To begin, I would invite the court to turn to page 28 of the electronic bundle and the 3rd paragraph. In that paragraph, that is the judgment of Lord Widgery in Taylor and Rajan. In that, he sets out the very crux of the issue, whether there was an emergency, whether if a man, in the well-founded belief that he will not drive again, puts his car into the garage, goes into his house and has a certain amount of drink in the belief that he will not be able to drive again, and thereafter there is an emergency which requires him, in order to deal with it, to take out his car, despite his intention to leave it in the garage, then that is a situation which can, in law, amount to a special reason for not disqualifying a driver. I submit that in this case, there was such an emergency and such a special reason. Later in...
Yes, Ms. Hazlitt.
Yes, of course.
If I may take that point, I note the same case you refer to also states that it's rare for the court to find a special reason when the defendant's blood alcohol content exceeds 100 milligrams of alcohol per litre of blood. Given that the appellant is therefore severely intoxicated, why should this court find a special reason in this case, given quite frankly the great danger he's posing?
Yes, my lord, I am grateful. The reference for your other lordships is on page 29 of the reference my lord is making. Yes, but I contend, I submit, my lord, nearly ever is not never. In this particular case, we submit that these 4 points, which I've already laid out, should be taken in the round. That yes, the appellant was 3 times the legal limit. He had 240 micrograms of alcohol in his blood. However, one factor, my lord, I contend, does not prohibit an appreciation of the other 3 factors and then a total in circumstance. I hope that answers your question, my lord. I am grateful. My lord, that was the first point I was willing to make, that actually, yes, the appellant did have a significant amount of alcohol in his blood. However, this was an emergency. And as we will see later, this is a matter for my lord's discretion. This is a simple matter of common law. And there is nothing in statute that lays out that between 80 and 240, this is a matter of discretion, and beyond 240, that is, the discretion is taken off the table. So my lords, I would turn to point 2 of my argument, which is point 2 of my skeleton.
Just before you do turn to point 2, I have a related question. In the exercise of the court's discretion, ought we not to take into account public opinion on drink driving and how that's hardened since the decision in Rajan in the 30 odd years since? And shouldn't that be an important factor in the exercise of our discretion?
Of course, my lord. I think the very essence of this law is to do with public policy and it's to do with public opinion. My lord, we would submit that I believe the public are understanding, and that yes, you should not drive while drunk, and we submit that that is absolutely the case. However, if you are taking public policy into account, we also don't want to end up with a situation where if there really is a grave emergency, which we contend in this case there is, with a risk to life and a potential explosion, no man would ever get in his car, even if he had a smidgen to drink, because of a worry he would be arrested. My lord, I would submit that in this case you have to weigh up the public policy of not allowing drunk drivers alongside the public policy of encouraging people to stop explosions. I hope that helps. Thank you, my lord. To move on to my second point, which is point 2 of my skeleton, this is an incredibly serious situation. There's a high risk of death. There is a high risk of damage. Now, my lord, it has been detailed in my skeleton how there is a factual there are similar facts in the case of DPP and Cox, which my lords will find on page 22 of their bundle. Thank you, my lords. In DPP and Cox, it was held that there was a developing situation akin to the one we have in our hands today. And in that case, it was held that there was an emergency because someone had broken into a golf club. Now, my lords, not to diminish the importance of golf clubs, but I would submit that in this particular case, this is an even more serious emergency, which involves potentially a loss of life and very dangerous situation indeed. My lords.
Ms. Hazlitt, is it not also a dangerous situation when a man 3 times the limit drives on a public highway in a 30-mile-an-hour zone, which is presumably so because of the risk of children being present? Is that not also severely significant and serious?
I thank you for the question, my lady. It is significant, and we do not pretend otherwise. But to that point, my lady, I think this returns to what was going to be my 4th point, which is the manner of the appellant's driving. Yes, he was over the limit, but he never exceeded 30 miles per hour, and he was only on that road for a maximum of 3 minutes, at half a mile. This is not to downplay the seriousness, as I've mentioned before, of drunk driving, but in this particular case, I submit that the potential danger of multiple people being killed in an explosion, which the appellant could have stopped, in this case in the round over, comes above the potential risk in driving.
I've heard a few times in cases such as this, the point that, well, he wasn't caught dangerous driving, etc. But isn't the point reaction time?
Yes, my lady, that would not be my point at all. I do not believe that if you're caught, then it's bad, and if you're not caught, it's fine. That is not the submission at all we're taking. I submit that in this particular case, the risk he took, whilst was dangerous, was in pursuit of potentially a greater danger in a giant explosion. I thank you for the question. I've laid out at the beginning my 4 points. I believe we've dealt with the blood content, the nature of the emergency, and just then with the manner of the driving. To finish on my 4th, which was my 3rd point, now my 4th point, whether there were any alternative methods of transport. We can see that in hindsight, there may have been a way to find other methods of transport. However, I submit that in this particular case, that there were significant reasons that the appellant was running against the clock to potentially avoid a tragedy. I would again draw back to DPP and Cox, where again there were alternative methods of transport, but it was held by the court in that particular case that it was a natural response. If you're worried that somebody is breaking into a building and that you can prevent it, it is a natural response to try and do what you can as quickly as you can. And I submit that in this particular case, that is also a natural response. Overall, just to sum up, I submit that in this case, you should take these factors in the round, that overall, looking at the circumstance, this was a special case. The degree and nature of the emergency, I submit, was of the most grave, and that cannot be understated. And combined with that, the appellant did all that he could to make sure that his driving was reasonable and that he was driving under 30 miles an hour. His blood levels were high. That is the very reason we're here. But when you take it in the round, as I said, this is a case where there should be a special reason. Unless I can assist the court any further, those are my submissions. Thank you.
Thank you, Ms. Hazlitt. Can we now hear from counsel for the respondent?
May it please the court, I appear on behalf of the respondent, the Crown. The respondent submits that the decision in the High Court was correct and should be upheld, as the appellant was not driving in an emergency and a special reason should not be found. I will be making 3 submissions today. Firstly, that there are a number of factors that are not met by the appellant for there to be a special reason. Secondly, due to the level of alcohol in the appellant's blood and the conditions on the road, he should not have driven. And thirdly, that the appellant should have made inquiries to seek alternative transportation. I shall now proceed to my first submission. Firstly, it is submitted that there are a number of factors to be taken into account when deciding whether there is a special reason. These were set out in the case of Taylor and Rajan, which can be found on page number 23 of the bundle and was referred to by my learned friend. The first factor to consider is the nature and degree of the emergency. I submit that whether this was an emergency situation depends on the facts. I submit that maybe this was not an emergency situation, as Mr. Miller was not the only key holder. He was not the only one responsible for the situation, and he should have sought alternative transportation. The second factor set out in Taylor is to consider whether there were alternative methods of transport or if other methods to deal with the situation were available. Mr. Miller could have got a taxi. He didn't. He could have ran. He didn't. He could have called Mrs. Cheng. He didn't. My lords, I submit that Mr. Miller had several options, and this test is an objective one, not a subjective one. My learned friend stated that because Mr. Miller was not aware that he would be driving in the evening, that when he was faced with the emergency, this amounted to a special reason. However, I submit that one of the aims of the Road Traffic Act on public policy grounds was to eliminate drivers driving whilst intoxicated. Therefore, considering this and the high level of alcohol in Mr. Miller's blood, a special reason should not be granted.
Yes, Miss Jarvis, thank you. If I could take you back to that submission you made a moment ago regarding all of Mr. Miller's alternatives, would it not be fair to say that Mr. Miller is, frankly, in a race against time here, against what could potentially be a catastrophic explosion?
My lord, it can be submitted that Mr. Miller was within a short time frame because of the likelihood of an explosion. However, the likelihood of his judgment being impaired and him injuring somebody of the public was far greater, and by driving on the road whilst intoxicated, he was endangering lives when he had other alternatives available.
Thank you. Do continue.
I submit that, for my second submission, I submit that given the circumstances of the traffic on the road and the appellant's high blood intake, he should have not chosen to drive to the lab. For this submission, I will be relying on the decision of Fraser and Barton, which can be found on page 30 of the bundle. It was stated here that it would be difficult for one to justify allowing the discretion when the appellant has an alcohol level of 230 milligrams per 100 millilitres. In the case of Fraser, it did not matter that his friend was dealing with a serious domestic abuse issue. Rather, the fact that his alcohol level was so high meant that he should simply not have driven. My lords, I submit that this should be applied to the current case, as Mr. Miller's alcohol level was so high that he was a danger to the public by driving on a public road. He should never have driven in such an intoxicated state, and he was lucky that the consequences of his reckless actions were not worse. It is not only the level of the alcohol, but the circumstances of the road at this time. Mr. Miller was driving at 5 p.m. on a busy Saturday afternoon in a built-up town. This should mean that no special reasons should be found, as this was a risk to the safety of the public. There could have been children or other members of the public on the road. My learned friend mentions that the appellant was driving at 30 miles per hour for only a short period of time. However, I submit that his reaction time would be greatly reduced and much more serious consequences could have occurred. If my lords have no questions regarding this submission, I shall now proceed to my final submission. I submit that the appellant should have made inquiries as to alternative methods of transportation and only driven as a last resort. Please may I refer, my lords, to the case of DPP and Knight, which can be found on page number 36 of the bundle. The case of Mr. Miller can be distinguished from the decision in Knight on the facts. This is because Miss Knight was faced with an emergency situation in which she tried all the alternative methods available. She contacted a taxi company and her friends, despite fearing for the safety of her young child's life. Whereas Mr. Miller had not attempted any of the several alternative arrangements for travel. His next door neighbour was a taxi driver and he still did not consider asking his neighbour to take him, despite the car being on the driveway and indicating that he was in.
Ms. Jarvis, could I ask a question at this point? Many of the matters you're raising are matters of fact that were before the original justices who heard this case. Do you accept that the justices in law were entitled to come to the decision they did based on their findings of fact, namely that because this was a developing emergency and it would be unclear how long it would take for the police to arrive, that in those circumstances the emergency was sufficiently serious? What in law have the magistrates got wrong, Ms. Jarvis?
I submit that the emergency was sufficiently serious. However, it is important to note that the magistrates may have overlooked the fact that there were alternative arrangements that Mr. Miller could have made. And following the case law, it's clear that one should look at alternative arrangements before deciding to get in a car intoxicated, despite the level of the emergency.
Is the Crown therefore inviting this Supreme Court to actually indicate that there should be a hierarchy of the four factors mentioned in the Taylor and Rajan case then?
I submit that all the factors are important when the court is making their decision today. I don't impose that there should be a hierarchy, but considering all of the factors, should there be a special reason is for the court to decide.
Thank you.
My lords, I would also like to distinguish my learned friend's use of DPP and Cox, as despite the similar fact pattern, Mr. Cox faced an emergency situation at midnight, so the alternatives available to him were significantly reduced. Also in Mr. Cox's case, he was driving to an isolated club, whereas Mr. Miller drove on a busy Saturday afternoon. The policy reasons are clear that we do not want people to be driving whilst intoxicated. And in Mr. Cox's case, he had 66 micrograms per 100 millilitres in his blood, whereas Mr. Miller has 240. To conclude, the decision of the High Court was correct and should be upheld, as the appellant was not driving in an emergency, and a special reason should not be found as Mr. Miller's alcohol level was too high for the court to exercise the discretion. This concludes my submissions unless I can assist the court any further.
Yes, thank you, Ms. Jarvis.
I think the judges will retire now, so I'll take this opportunity to hand over to Lord Weir for judgment.
Oh. Yes, my lords, this is an appeal from the High Court by Mr. Miller on a point of law of public importance, namely whether the list of criteria in the case of Taylor and Naraja 1974 is still good law, and whether there should be further guidance from this court how this criteria should be applied in light of the public policy shifts since the Taylor and Rajan decision. The authorities in this case all demonstrate, that have been referred to as by counsel most ably, are that the factors referred to in Taylor and Rajan are just as valid today as they were 30 years ago. And as Miss Jarvis on behalf of the Crown conceded, there would be little to gain for this court to indicate any type of hierarchy in relation to judicial discretion. Therefore, we decline to give any further guidance than the words already given by Lord Justice Widgery, or Chief Lord Justice Widgery, back in 1974 on the criteria to be applied in cases of special reasons. In this case, therefore, we need only ask one question. Could the reasons put forward in this case by the appellant amount to special reasons in law? It is clear to us that they could. And the next question is whether the justices misapplied the law to the facts and that no reasonable bench of justices could have reached it. And our answer to that question is a no. Accordingly, we quash the decision of the High Court and reinstate the decision of the original justices. I will now pass over to my Lady Keeves, who will now give some comment and feedback as to the excellent mooting we have heard this afternoon.
Thank you. Yes, so well done to both of our mooters. It was very impressive, not only with the quality of the mooting that we heard, but beyond that, everyone commented on the progress you've both made throughout the competition today. One of the key skills is always going to be, even at our level, listening to feedback, learning from listening to other people do mooting, other people do advocacy, and clearly that is a key skill that you both possess. So many congratulations to you both, and given that you have that skill, there's no doubt that you will go on improving beyond the high standard that you are both already at. Turning individually, Annabel, you had good signposting, and that comes back to my point about learning from the previous feedback, because I know that's something we've discussed before. You dealt with the judicial intervention very well. You had some back and forth, largely from me, but you dealt with that well. You dealt with the pressure of that well. The reason I came back and forth was because I wanted you to get to the point of balancing out the levels of dangers between the two scenarios, and you did that. It's a point about listening very carefully to what you think is being asked and how best to answer it. So it's better to take a pause, and you can even say, if I can just have a moment, we appreciate that you're not a robot who's pre-programmed with answers, and we would rather you take that beat and consider your answer and give it clearly the first time, because you won't always be given a second opportunity, but you did get there. So well done for that, and well done for dealing with the pressure of that. What particularly impressed us was when you had the other judicial intervention, the judge spoke about a particular part of a case, and you referred to the reference for it, page number, etc., for the benefit of the rest of us. And that was very helpful, because you're faced with a panel of judges, and it's a way of making sure we're all paying attention, we're all drawn into that conversation, even though it isn't just one of us who's asking it. And that also assisted with it coming across very naturally. What in particular we enjoyed, Ben and I, was your stealing of your previous opponent's phrase, which I had noted was particularly interesting and good. And that's good. Do it. If someone comes up with a good phrase and you can use it in another case later, do it. So well done for that, and well done for having having the gumption to do it, knowing that Ben and I were sitting there. It was impressive that you did that. I think you were asked about public opinion. A good way of dealing with that would have just been to say, actually, the question is public policy. You have to be careful because you have to answer the question you're being asked, and you have to do it in a polite way. But opinion isn't actually necessarily the point. You need to look at public policy because, you know, we've all known through the political decisions that have been made, public opinion isn't always the way that we should go. No further comment. So the so you dealt really well with things. You made massive improvements. You were very clear. You had a nice pace. You had a good introduction. You ummed a little bit. You just take those beats, but overall a very good performance. Well done. Melissa, you had a really nice pace. You could we could follow what you were saying. You didn't speed up, which is often the case when people find their grounding. They get going and speed up. You used the bundle, you used your page numbers, all of that's very good. You used your skeleton. Be more confident about what you're saying. You were making the point that he may have been endangering lives when he was driving, and it almost felt like that point bored you a little bit. So there's a difficult balance to strike, and I always struggled with this, between being professional and injecting some personality into it. And there is a way of being able to do that will come the more you practice and the more comfortable you become with it. But it's okay to have your personality within the submissions you're making, and it engages your audience, in this case, a large number of judges that you were speaking to. The most significant thing for you to work on is it felt very scripted. We felt, and this is something that comes unfortunately from doing Zoom advocacy, that we could almost see your eyes moving across your script. So do try and pull away from a scripted approach, whether that be that you change it to bullet points or you practice more before you come on. If you have a script, you will almost always use it. I never walk into court with a script, even if it started off that way, because you have to trust yourself a little bit, and you have to trust that you know the material, and clearly you do know the material because of how you dealt with things like the judicial intervention, which was extremely difficult questioning, actually, on legal points. So just bear that in mind. But with regards to pace and the points you were making, and your structure was very nice, all of those things are very positive. So well done to both of you. I shall now pass over. It's such difficult on the screen. I think Mark is giving the results. Yes, there we are, Mark.
I think it falls to me as the second most senior after Darren, who gave the judgment to the court, to give the judgment of the moot. And we've decided after some deliberation that today's winner will be Annabel.